Welcome to the Family Law Frontline.
Welcome back to the Family Law Frontline with Fedor Kozlov. Fedor is the founding partner and chief litigator at the law office of Fedor Kozlov, PC, with over a decade of experience in Illinois family law. He handles high stakes cases involving custody, property division, domestic violence, and complex divorces. I'm LeAnn Lyon, and today we are talking about 604B psychological evaluations in Illinois custody cases and how they can influence a judge's decision. Hello, Fedor.
Hello, how are you?
Oh, wonderful. It's great to see you again.
It's
So, when a judge orders a 604B evaluation in a custody case, what concerns or dynamics usually lead the court to take this step?
well, 604B is a very, very technical issue, to be honest. Uh, I came across such issue only handful of times in my experience. 604B is something that can be ordered for parents to be evaluated or for children to be evaluated. Usually, one of the parties, have to file a motion for 604B evaluation and allege specific instances and reasons why it's necessary. As we know, children in cases like that usually represented by either a GAL, guardian ad litem, or child representative, and GAL cannot file any kind of motions or petitions on behalf of the children just because of the scope of GAL's representation. And child representative is an official attorney of a child or children, and he or she can file those motions. Usually, 604B has to do, it's a little bit of extreme measure. Uh, it's not cheap, and it's not, it takes time as well. So usually you have to file a motion. So it can be either filed by a father or by a mother to evaluate the other side. If we're talking about parents, it's usually, it usually applies for both parents. So both parents would have to do that. If for children, then it's usually because of the behavioral issues of children towards one of the parents, and it follows up by some kind of therapy with the child, like reunification therapy or just therapy in general. But 604B is a court proceeding under the Illinois statute, and it has some necessary requirements that has to be alleged, pled, and the judge has to approve it. Um, Usually courts don't just order people to go through 604B evaluation. It has to be done by one of the parties or child representative.
So, how does it differ from a guardian ad litem or a child representative investigation?
Well, child guardian ad litem or child rap investigation usually would cause or lead the 60 lead into 604B evaluation. So if and again, if we're talking about parents, we're talking about children, the with the guardian ad litem might submit a report to court of his or her observations of people and suggest 604B evaluation. Now, if both sides are in agreement, then the court's going to order it. If both sides not in agreement, one of the parties has to file a motion. Same with the children. For the child rep, a child rep can just file a motion for 604B evaluation. And again, it's after child representatives evaluation, or it's after child representatives report or investigation. What 604B essentially is that It's a court ordered psychological evaluation of someone, either children or the parents. And it's conducted by an approved therapist, and the therapist would draft a report and submit it to the parties in the child rep or guardian ad litem, and that report will become a basis for the further uh, report of the child rep or guardian ad litem. The therapist can testify later if we go into a trial, and the therapist can be cross-examined by the parties based on that report as well.
So, can you walk us through what a parent actually experiences during a 604B evaluation?
Of course, I can. I need to know also something that I like. I said, it's a very rare occurrence when 604B evaluation is ordered. Um, I saw a lot of times when 604B is abused in terms of, unfortunately, it's abused in order to pressure the other side. You know, divorce is it's a war between sides sometimes, and unfortunately, sometimes it involves children. So I saw people, lawyers, also filing 603 604B requests, subject to
Mm.
137 sanctions, just to pressure the other side. If you see that the other side is vulnerable and not presented by a lawyer, unfortunately, it happens. In the case that I have in my mind when I speak to you about it, it's a case when the mom refused to give the father any um, visitations of the children. There's a term that we use for uh, situations like that. It's called helicopter mother. That would not allow the father to see the children, spend any time, make any decisions. In that case, she even refused, she would not accept any presents for children from the father for Christmas, for Thanksgiving, for their birthdays. There were four children. The children were on home study, so they did not communicate with anybody else. They only knew the household, and the mom lived with her parents. The mom didn't work; she stayed at home, and she would not let the father see the children even during court order parenting time. So in that case, we had to go through 604B evaluation on the motion of a father in order to evaluate the well-being, psychological well-being of the mother. Um, and again, like I said, it has to be very specific allegation as far as the 604B is concerned, which was approved by the court, supported by the guardian ad litem in that case, and then there was an evaluation. So the mom and the father separately met with the therapist, uh, answered questions, things like that. It's very, you know, sacred therapy. It's not disclosed to public, of course, and the therapist doesn't share specific things that were exchanged, but the therapist would write a report, and based on his or her um, education and experience, would make suggestions. So in that case, even though it was somewhat extreme, therapists came to the conclusion that no additional therapy is needed. The parties simply need to comply with the court orders, and that was the basis for GAL's further recommendations, things like that. So, like I said, 604B, it's somewhat a medical procedure to the extent, but this done for the purposes of the court.
Have you handled a case? I mean, you were kind of describing one right there. Did that significantly shift the direction of the custody litigation? And what in that report carried the most significant weight with the judge?
The therapist is an expert. Uh, Lawyers not experts in the medical field, and certainly the parties are not experts. Even though, I hear from the parties all the time he's a bipolar, or he's a narcissist, and whatever the people say about each other.
Mhm.
But they're not experts. It's just a label that they try to attach to a different person. So to have to call somebody a bipolar or something like that, you have to have an expert. So the therapist is an expert, and to answer your question, the expert's testimony is always valued by the court. So we have a bunch of rules, and since we're very procedural in this podcast today, 604B, uh, it requires a disclosure for the court purposes, and we have a separate rule called 213F. That rule. That rule talks about the witnesses at trial. 213F is a lay witness who would be a father or the mother. 213F and 213 F2 and F3. These are controlled or not controlled witnesses. So if you're thinking about a witness that is not controlled, that's going to be a therapist, in this case, a police officer who are experts in their fields, and then they're not paid specifically by one of the parties to testify on their behalf. Now, if one of the parties don't like what the therapist said, you can always challenge that report, and you can always impeach it by having your own witness, 213F3, who will testify on behalf of, who you paying money to testify on your behalf. And that expert has to be qualified in in the medical field, and that expert can tell the judge that don't listen to this expert, listen to me, because I have better experience, better knowledge, and things like that. But usually it doesn't have, because 604B evaluation is an expensive procedure, and both parties usually pay for it. And it's usually not covered by your health insurance. So you have to pay for it. And people usually don't challenge the 604B expert evaluation, so the court will listen to it.
Do they have to listen to it if the expert provides it? I mean, is the judge required to follow what the expert recommends?
Oh no, judge doesn't require to follow what the expert recommends. The judge is what we call a trier of fact. In family law, it's always a judge, it's not a jury. So the judge will listen to the expert, and what the expert has to provide is just a piece of the evidence for the
Right.
judge to make the ultimate decision as far as the custody or whatever the issues are. It's a valuable experience coming from the expert from the field that the judge might not be even familiar with. But then you also listen to the GAL. You also can challenge or cross-examine that expert witness. You also listen to the testimony of the parties and children usually testify through GALs. GAL is what we call they are the eyes and the voice, the eyes of the court and the voice of the children. So their testimony is extremely valuable as well. But it's hard to fight the expert testimony, and usually the grounds for the further appeal, if people decide to go with the Court of Appeals, would be that the court neglected to include expert opinion, or would be that the court took way too much of the expert opinion. So that's usually what would be the grounds for the appeal, the expert's testimony.
So, what are some strategic considerations for attorneys when preparing a client for a psychological evaluation in a high conflict case?
Well, we're not supposed to prepare a client. Um,
Mm.
uh, you can't really prepare. You can prepare a client for the trial, what to say, what not to say. The client has always to say the truth, so he or she not subject to perjury during the trial. I always tell the clients that you need to disclose, you need to tell the facts. The facts are the facts. You cannot hide the fact. If you hide the fact to a therapist or to a judge, it doesn't look good. And then you can always be caught in a lie. And if you're caught in a lie or being not truthful, not forthcoming, always going to be negative impact on you. The facts are the facts. You cannot lie about it, but you can always explain it. And that's, I
Right.
think, the most valuable advice I tell the clients. Like, I don't really prepare clients, like, and I hope other lawyers don't do that either. What exactly to tell the client? We call it coaching. We cannot coach children. That's what parents unfortunately do from time to time. You cannot coach, and it's easily to find out. If children is coached, an experienced GAL or therapist can easily find out that. And same with parents. If you coach the client too much, it can be easily discovered they're going to be against the client. You can always we live in real life. People live in real life, and just because something happens in real life and not in accordance with some kind of uh, rule doesn't necessarily mean that it's bad. You parents always must behave in the best interest of the children. That's what actually the courts are saying, that even though you have this agreement that you have to have this kid at 12 o'clock on a Saturday, but let's say there's something else going on in that child's life, would be in the best interest of this particular child. So then you can go and have an agreement outside of this court order or outside of this parenting plan, as long as it's in the best interest of the child.
So, just as we wrap up today's episode, and this is for parents who are maybe feeling anxious or defensive about undergoing a 604B evaluation, how should they approach the process so that they both protect their credibility and their case?
I'll tell you this. I don't like 604B evaluations at all. I feel like it's intrusion in your privacy. It's somebody who wants to pick up your mind, and you're meeting with a stranger, and the stranger will make a recommendation to the court, and custody of your child might depend on that, and you don't trust that stranger, and it's absolutely normal feeling. I don't like 604Bs. I try to avoid them as much as possible, but sometimes it's out of my control. Um, with children, it's even worse, I think. So not only the parents are getting divorced, it's pressure on the child, especially a teenager. And then now he or she have this new strange people in their lives, like a GAL, right? So this child maybe doesn't want to talk to GAL or anybody else about his parents being getting divorced, and the only reason you have a GAL or therapist or a child rep is because your parents are not cooperative with each other and they hate each other to the point that you have to talk to somebody else now and resolve their issues for them, and that upsets me a lot. Like, why parents cannot just figure out things themselves? Why do they have to bring other people in the life of your children? And now you have opposing counsel, another opposing counsel, you have a judge, you have a GAL, you have a child rep, and you have a therapist, and the child has to talk to them, and
Right.
it's very upsetting, and I think it has a negative influence on the child's mind. All these therapy sessions, instead of playing with other kids, he has to
Yeah.
go to the therapy session. So if you want to think about it, it kind of doesn't sound very well. So the strategy, there's really no strategy. If it's ordered by the court, you just have to be done with it. That's all. You have to comply. And if you're not complying, unfortunately, you might dig your own grave, so to say. You just need to go through this and be as candor and as upcoming and upfront coming as you possibly can, and just be done with it.
Well, it's a heavy topic, but thank you for going through that with us today. And to our audience, that is it for today's episode of the Family Law Frontline. If you are involved in a custody dispute where a psychological evaluation has been ordered, you can visit lawyer-il.com to connect with Fedor Kozlov and his team. Thank you for listening, and remember to like, subscribe, and share this episode with someone who might need it. Thank you, Fedor.
Thank you, Lam.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.